Major breaking news we have in the United States District Court for the Western District of New York out of Buffalo, the case of Christian versus James in front of Judge Sinatra, a big fight over quote-unquote sensitive places, which is a euphemism, political propaganda term, for government-mandated gun-free zones. Let's talk about this huge oral argument that occurred just now in New York. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Terrorist Attacks on Israel Teach Americans About the Right to Bear Arms. We must learn from history so that we in America never get disarmed. Very important to learn the lessons of others around the world and throughout time to make sure we don't lose the fundamental right to keep and bear arms. Check out Israel Disarmed, a lot of American history as well as Jewish history and international history, a lot of information you can use in your local private debates defending our right to keep and bear arms. All right, folks, major oral argument in federal court in New York, specifically in front of Judge Sinatra in the United States District Court for the Western District of New York out of the Buffalo, New York area, the Niagara Falls area, if you will. Big fight, big fight. This involves the so-called New York sensitive places rules. Now, sensitive place is a phrase that arose out of the Heller case by the U.S. Supreme Court in 2008. It was forced upon Justice Scalia to get the fifth vote in the form of Justice Anthony Kennedy to win the 5-4 victory in favor of the Second Amendment in Heller. That was language that Justice Kennedy insisted upon placing into the Heller case. And of course, as you know, when you write Supreme Court opinions for the majority of the court, it is really a operation of a committee in the sense that all these justices get to weigh in on every comma, footnote, language, and sometimes they insist on language that other justices disagree with, but they go along with it. I think that was the case with the quote-unquote sensitive places issue, which again is a euphemism for allowing government to ban guns, create gun-free zones by government mandate, even if, and here's the key, even if you have a concealed carry permit, you've already been vetted by the state of New York, or any state for that matter. You've been totally vetted. You're allowed to conceal carry in your state, for example, and yet there's still places that they can say you cannot bring a firearm. And of course, there's a question as to whether or not those places are when the government mandates that they are prohibited from allowing guns in there, or you're not allowed to bring a gun into a particular place, there is Second Amendment questions because it's infringing upon your right to keep and bear arms. And then the question becomes, is there a constitutional basis for allowing this, or is the Second Amendment prohibit that kind of gun law? This case involves many plaintiffs, including the Second Amendment Foundation and the Firearms Policy Coalition. Big argument. And the two main issues presented in this argument were public parks. Now, and the other one is the so-called vampire rule. Now, let's just start quickly with public parks. Judge Sinatra indicated he's not going to rule on the public park issue because he believes that the United States Court of Appeals for the Second Circuit out of New York City, which has jurisdiction over Judge Sinatra, he says that the public park question is still being presented to the Second Circuit, so it makes no sense for him to rule on that issue since a superior court is already looking at the question. So he said he's basically going to just wait on the public park question, i.e. New York's ban of you can't bring a gun into public parks. So it sounds like Judge Sinatra is not going to weigh in on that. He's going to wait for the Second Circuit Court of Appeals to issue a ruling, and then he will handle it from there. So that meant that the argument was mostly about the quote-unquote vampire rule. Now, the vampire rule is a metaphor, a shorthand reference to what is also known, if you want to be more technical about it, the presumption rule or the default rule that says that the default rule is, according to these laws by anti-gun states like New York, is you are not allowed to carry a gun on private property without getting the consent of the owner. And that goes to not just carrying guns into residential property. It also applies to carrying guns into private property of businesses that are open to the public. For example, gas stations, convenience stores, supermarkets, malls, and so on and so on. These are private businesses that are private property, yes, but they're also open to anyone. They're open to the public. So the way the New York law works is you're not allowed, even if you have a concealed carry permit, you can't carry a gun into these places without the permission of the owners of these places, these businesses. And therefore, if they put a sign up that says concealed carry holders are allowed or guns permitted, that's fine. But if there's no such sign under the default rule, according to the New York law, the way it's written, you are not allowed to bring a gun onto the property. Now, this is almost certainly unconstitutional, and virtually every court that has addressed this has found it to be unconstitutional. I think there's one exception for the Ninth Circuit as applied to Hawaii. But other than that, every court has found this to be unconstitutional, because if you think about it, it's like if government passes a law that says you cannot pray in any private place, you cannot wear a Trump hat, you cannot wear a piece of jewelry that reflects the cross, for example, without first and foremost getting permission from the owner that you're allowed to wear it. That stands American life and liberty and freedom on its head, where the presumption in a free society, which we have here in the United States, at least we've had for 200 plus years, in a free society, you are allowed to do anything you want unless it's prohibited, unless it's banned by law, unless it's somehow restricted by law. That is the reverse, of course, default or presumption that we see in a totalitarian regime that says that you're not allowed to do anything. You're not allowed to do anything unless you first and foremost get permission from the government. This is the old English system in many respects, where you're not, for example, allowed to hunt on private property or in public property without getting permission from the king. That was a little bit different rules, for example, in the United States. Now, with this said, this was where the argument laser focused. Now, a couple things. There was not a lot of discussion about which are the relevant, because we're going to talk about analog laws in just one second. There was not a lot of discussion here about whether or not 1791 is the relevant time period or 1868. Because this involves a state gun restriction, New York State, the 14th Amendment plays a role, because they use the 14th Amendment to incorporate the Second Amendment through the 14th Amendment and apply to states and localities, because the original Second Amendment standing alone only applied to the federal government. Now, the Second Amendment, along with the Bill of Rights, was adopted in 1791. It was not until the 14th Amendment was adopted after the Civil War in the year of our Lord, 1868, where effectively that 14th Amendment grabbed the Bill of Rights through what's known as the process of incorporation, and applied to the states and localities, which occurred over time with court decisions. Okay, but there is a debate here. Remember, the anti-gunners, and I've written about this extensively, including in the Harvard Journal of Law and Public Policy. I'll try to put a link to that article down below. It's cited by many judges and others, I believe, as I recall. Basically, it talks about how 1791 is the relevant time period for understanding the scope of the Second Amendment, and that the U.S. Supreme Court has repeatedly found that to be the case. To me, most prominently in recent years, in the Espinoza versus Montana case, that said that 30 state laws that were enacted against religious freedom in the late 19th century, which would have been in the time frame of 1868, are considered too late in time to have any significance in terms of understanding the meaning and applicability of the First Amendment. Now, the reason why this issue between 1791 and 1868 has practical consequences to your right to keep and bear arms is because the anti-gunners want to look to 1868 in that time period, because there are more gun control laws in that late 19th century period than there were in the 18th century. And a main reason why you had a lot more gun control laws in the 1868 time period is because there was an effort by a lot of the southern states after the Civil War to disarm blacks in a new way, because you could disarm blacks through the slave codes. After the Civil War, you no longer had slaves, so you no longer had slave codes, so they converted the slave codes into what were known as the black codes. And there's a lot more gun control laws in the late 19th century that the anti-gunners can draw from as historical analog laws to justify modern-day gun control laws. And that's why we want it to be 1791. The anti-gunners want it to be 1868. Now, in this oral argument in Christian versus James, this did not play a big role, but it seemed clear that Judge Sinatra is basically more interested in 1791, which, based on the Supreme Court's Espinoza versus Montana case, makes a lot of sense. And based on the whole Supreme Court jurisprudence, 1791 is clearly the right answer. And that's what the Supreme Court will ultimately decide unequivocally when it comes to the Second Amendment, in my view. And the only reason why they hold back doing it now is because there's an intramural battle internal to the U.S. Supreme Court over the role of the Privileges and Immunities Clause, which Clarence Thomas has a particular view on, which I'm not going to get into in this particular video, but there is an intramural squabble over that role of the 14th Amendment Privileges and Immunities Clause, and that is causing a little bit of basically delay in the obvious answer of 1791 being the right year for applying the Second Amendment and for interpreting the Second Amendment, because that's what they do for the rest of the Bill of Rights. But again, with that said, I don't think this is going to be a big issue in the Christian versus James case, because either way, I think that the default provision or the presumption provision or the vampire rule should be declared unconstitutional. Now, the reason why it's called the vampire rule, again, as opposed to just the default or the presumption rule, is, of course, the notion of vampires historically in the world of fiction is that vampires are not allowed to enter a home or a place without first and foremost being invited in. And the metaphor is that you're not allowed to bring your gun into a private place or a private business without first and foremost being given permission to do so. And that's why they use the vampire rule as a metaphor on X and places like that. Now, what happened in the argument was, after the public park issue kind of resolved itself, he's not going to decide that. Then you got into a fight about, are there historical analog laws that justify a default vampire rule presumption that says you cannot carry guns into businesses without first and foremost getting their permission? And if they're silent on the question, then you're not allowed to bring your gun in and exercise your Second Amendment rights. This is somewhat absurd, of course. The whole notion about the Constitution is everywhere you go as an American citizen in our country, you have constitutional rights that attach to you as a citizen, period, full stop. But there are arguments that the anti-gunners made, the state of New York made. Of course, it was simply conceded, really, for all intents and purposes, that the text of the Second Amendment was implicated by this law, because the right to keep and bear arms means, of course, the right to possess guns, and the right to bear means the right to carry guns in public for self-defense. And if it restricts your ability, if government passes a law that restricts your ability to carry a gun for self-defense in a particular public place, like a gas station, a supermarket, a mall, whatever, obviously that hinders your ability to exercise your right to bear arms, and because it hinders your right to exercise your right to carry a gun for self-defense in public, that is an infringement, as in the right of the people to keep and bear arms shall not be infringed. And once the text is implicated in that way, which clearly it does, you know what happens? The burden shifts to the government to show there's some sort of long-standing historical tradition going back to the time of the founding that would justify this kind of law, this analogous to this law. And the best example I like to give is, again, the fact that the Second Amendment exists does not give us a right to commit cold-blooded murder. And the way we know that is that throughout world, really, well, American history, Anglosphere history, and American history and English history, you've never had a right to commit cold-blooded murder. So even though there's no exception for cold-blooded murder written into the text of the Second Amendment, that is there by virtue of a long-standing historical tradition of a type of firearm regulation that says you can't use guns to commit cold-blooded murder, or any other weapon for that matter, any arm to commit cold-blooded murder. And that's the kind of long-standing historical tradition that the anti-gunners of the state of New York are looking to find here. And the only thing they really came up with, if you look at their briefs and whatnot, is they really talk about hunting laws, which are really a form of trespass law. But if you look carefully at those hunting laws are really basically saying you can't bring guns onto property to engage in the act of hunting. If all you're doing is carrying a gun for the purposes of just self-defense, there's not anything that speaks to that issue. It only says that you're not allowed to bring a gun onto a particular property if you're going to engage in hunting. And if you're bringing guns on the property to engage in hunting, well, guess what? That is an anti-hunting, anti-poaching rule. Has nothing to do with what these laws today deal with, which has nothing to do with hunting. They just don't want you carrying a gun for self-defense. So you're not trying to preserve the population of animals or respect property rights through government actions or anything like this. You're basically just trying to say we don't want people carrying guns because we think it's dangerous, and that is simply not analogous to the concerns about hunting. Meaning the why of those laws, the why of the hunting laws is we want to preserve, protect animals and property owners of those animals from illegal, unlawful hunting. But even there, in most cases in the United States, the only way you are barred from hunting is if there's some sort of a posting notice that says, of course, you can't hunt or fish on my property. And if that's not there, the general presumption in American life is you're allowed to hunt, as you know, as long as you have the license and you're within the season, and so on and so on. But anyway, the anti-gunners in New York State were really trying to use these hunting laws as a basis to justify the default provision, but I think it's a little little bit of a stretch. The other thing we saw, and this is why I mentioned the 1891 versus the 1868 issue, the 1791 versus the 1868 issue, is because there was a lot of discussion of the black codes. And again, the black codes are laws that appear on their face to be neutrally sounding, that were enacted by southern states, Confederate states, former Confederate states, to make it look like they were trying to be honest and neutral laws involving gun restrictions. But the reality was they were enacted so they would be enforced against the blacks, the former freed, the now freed former slaves. And that, of course, as you know from Justice Kavanaugh's concurrence in Rahimi, and basically also references kind of in Bruin, I would argue, but it's pretty clear that the Supreme Court does not view that laws that have a racial animus associated with it or an anti-religious animus associated with it, something like that, to be considered a viable analog law that modern-day gun controllers can use, because it's basically viewed as part of American history that has been left behind. And it's pretty clear these black codes, which were motivated by anti-black racist intent after the Civil War. Again, you go from the slave codes, which they got rid of with the 14th Amendment, but then they embraced the black codes, which was really the slave codes rewritten in neutral sounding language to apply to blacks as opposed to the slaves. And then after the black codes, of course, it gives rise to Jim Crow, and it goes from there. We know that history. But the Supreme Court has said that that history is left behind. We're not allowed to use that, meaning the anti-gunners in New York State cannot use that to justify modern-day gun control laws. So there you have it. We'll see what happens in the Christian versus James case out there in the Western District of New York. Big case in New York. We'll find out. I don't know when the judge will make his decision. As soon as I hear something, I will let you all know. And make sure you follow me on X at 4Boxes Diner. Don't forget to like and subscribe to this channel and like this video. And we will see you again very soon, I hope, here at the 4Boxes Diner.
Orders up. Table 2A.